Good afternoon, everyone. Thank you so much for joining us today. I apologize for the little delay. We wanted to make sure everyone had time to get on, as this is always a heavily attended webinar. Just a few housekeeping items. If you want to ask a question, and I know there will be many questions, please type them in the question box, and at the end, Mike will answer those questions for you. We're asking you to give us about 7 to 10 business days for the credit to appear in your portal. And if at any time you lose connectivity on this webinar, please notify us immediately, as well as trying to get back on immediately. But reach out to us via email or phone if you have any issues. At this time, I would like to welcome Mike, our Executive Director, who will be presenting today. Welcome, Mike.
Thank you, Kelly. Thank you, everybody, for joining us. This is our annual CE on the final disposition law in New York State. The good news is nothing's changed. For those of you who've been on in the previous years, nothing's changed over the last couple of years. So I guess it's good because you don't have to know anything new, but it's bad because you're going to hear me give the same spiel as I did last year. So let's get into it. I know there's usually a lot of questions at the end of this one, so I will try to make sure I leave enough time to have those questions answered in the hour that we dedicated for this. So let's head through. So the final disposition law is now not so new in New York State. It was first enacted and became effective in 2006. This law has been amended 3 times subsequently in 2007, 2012, and 2 years ago in 2022. I will touch upon all 3 amendments and what they did as we go through the slides. The purpose of the law was to create a priority or next of kin list so that you would have some direction as to who could control disposition. It was also, a purpose was also to create the ability to appoint an agent or a legal representative who could control disposition. A third purpose was to create liability protections for both you as the funeral directors and for the agents who were, or the people in control of disposition. And the fourth was to help deal with dispute resolution. In essence, it became a roadmap for funeral service when it came to disposition. I've said this before, but I think it's worth noting that prior to this law, funeral directors have had to deal with the question of who controls a person's final disposition. Increasingly, funeral directors found themselves in the middle of a disagreement, an outright dispute amongst family members as to the method or procedure of a loved one's final disposition. And as you well know, in addition, the landscape has been altered by the complexities and realities of today's society, which includes a lot more non-traditional family structures. So this factor presents an emerging legal and practical challenge for funeral directors who are looked at by the decedent survivors to make the decision as to which of them has the legal authority to control their loved one's final disposition. However, as you are well aware, each situation is unique, and funeral directors are not always made aware of all the facts in a particular case. It's also extremely important to note that prior to the law, New York State did not provide funeral directors with any specific guidance on how to handle these situations or any explicit legal protection when doing so. As also you are very well aware, you guys are often put in the uncomfortable position of taking sides with one party over another, and by extension, seemingly endorsing a type of disposition that could ultimately be found to be contravene the wishes of either the deceased or the loved one who's actually possessing the legal control. Of course, the irreversibility of cremation raises the stakes even higher. Needless to say, such a role goes well beyond a funeral director simply acting in a less risky, albeit important position as mediator or arbiter. Unfortunately, these situations and circumstances cannot be avoided, but thanks to the final disposition law, funeral directors have heightened levels of clarity in dealing with family disputes, as well as significant liability protections that have been non-existent prior to the law in our state. One last note before I start walking through this. I have just said this is a New York State law passed by New York State. So as I walk through the statute, remember this is a state law. So it only applies when someone dies in New York. The only exception is when a person dies outside of New York, but they have either a valid agent form, one of our agent forms on file, or they have a will that is valid under New York law that addresses disposition, and the disposition takes place in New York State. So again, it's a state law. I'm going to emphasize a couple of points like that one that are things that I hear, or Kelly and I hear in terms of questions that come from you throughout the course of the year. So hopefully we can address some things that might pop up for some of you. One other disclaimer before we begin. Because we're reviewing the law and specifically the statute, words are very important. So I'm going to rely a lot more on reading some of the slides and the words than I normally do, because it's very important to use the words that are listed. I'm also going to walk through it in terms of the way it's set out in the law, first section through the last section. So it might seem out of place compared to how you usually deal with this or think about it, but that's the way that I think it will help us walk through this the best. So let's start walking through. Not surprisingly, the first section of a law is usually the definitions. This law does not contain very many defined terms. The only 3 defined terms it has are disposition, domestic partner, and person. So we're going to walk through each of those. So as you can see on your screen, disposition means the care, disposal, transportation, burial, cremation, or embalming of the body. So in general, it's really trying to touch upon all the times you would be handling the deceased when it comes to defining what disposition means. The second term is domestic partner. So what is a domestic partner? So it's kind of a long definition, but it's how one person relates to another. So in this case, it's a person who to another person is formally a party to a domestic partnership under federal or state law. So in New York, if you wanted to do it under state law, which is a law, you would file, and if you became domestic partners, the partners would have a certificate of domestic partnership once they're approved. So that would be your evidence. 2, it could be where you're registered as a domestic partner of a person with an employer or any federal, state, or local municipality. In New York State, people can register as domestic partners under both New York State law and New York City law. There are a few of the larger municipalities, I believe, that also allow for domestic partners. It is just called a domestic partner registry. Third is you are formally named as a beneficiary or covered person under another person's employment benefits or health insurance. Self-explanatory. And the last is it's dependent on, mutually interdependent on other person for support based on the totality of the circumstances. This is the one that we get the most questions about. There are very few people who come to funeral homes with a certificate of domestic partnership or evidence of the registry, or where they're showing that they're named as a beneficiary. So then you're left to what's the totality of the circumstances. And here's the list of things. None of them are more weighty than the other. It is really based on all of these things together. And what are some of the things that would prove that the people meant to be domestic partners and not just roommates? Common ownership of property. Common householding, meaning you're buying food together, you're paying expenses together, you have income that you share together, you could have bank accounts together, things of that nature. You have children in common, you had signs that you intended to marry or become domestic partners, and the length of the personal relationship. Clearly, the longer you are together, the more likely it is that you would be able to prove that you are domestic partners, because you're going to have things like common householding and shared expenses and income over a longer period of time. It's important to note, however, that as funeral directors, you are not required under the law to obtain proof of a domestic partnership. So the law says you don't have to. When we get questions here at the office, we always try to be more cautious, and our recommendation is to make a reasonable effort to try to gather some information that from the person who's claiming to be the decedent's domestic partner that supports that. So they could show you shared electric bills, they could show you a joint bank account, they could show you a mortgage together, something along those lines that will just help further the cause. But at the end of the day, you can take what they are saying at face value, because they are the ones who are attesting that they are the domestic partner. In addition to telling us what is a domestic partner, this section of the law says who cannot be a domestic partner. This is commonly referred to as the anti-incest rule, and you can see why as we walk through this. So you cannot be the domestic partner of somebody else if you are related by blood or marriage, if you are under 18 years old, if you're an adopted child of the other person, or if you're related by blood in a manner that would bar marriage in New York. So there's certain familial relationships in the state law that say if you are of this connection, you are not allowed to marry the other person lawfully. That rarely ever comes up, but if it ever was something you were concerned about, you could always reach out to us and we could give you that list of what those things are. The last definition is person. So that's pretty simple. It's a natural person, meaning a human being who is at least 18 years old or older. That is the legal age of majority in New York State. So they're saying that, again, kind of goes into the domestic partner piece. You cannot be a person who's in control of any disposition unless you are a legal adult. Sliding over to the second section of the law, it starts with what is the thing we get the most calls about, which is the priority list. So let me work through this with you. So this is how the law reads. The following persons in this descending order, which you can see I have it listed there, have the right to control disposition, provided that if there are more than 2 members of a class listed in subparagraphs 3, 5, or 7 entitled to control disposition of remains, the disposition shall be determined by a majority of the members of the class who are reasonably available. That was the 2022 amendment. So basically, I have it highlighted for you. If you have a situation where you have 3 or more people in a specific class, so the decedent has 3 or more children 18 or older, or 3 or more siblings 18 or older, or we'll get into the details of the people who are entitled to share, but 3 or more people who are entitled to share in the decedent's estate, then you need majority of those people to agree in order to move forward. All right, so what's the descending order? Number 1, person designated in writing through the agent form or a will. So we're going to get into a little bit more of the agent form as later, and I'm also going to give you some details as to what the wording must be in the will for it to qualify as the writing under this section. Number 2 is a spouse. Important to note, way back in 2011 at this point, New York passed the New York State Marriage Equality Act, which means now that spouse can include same-sex spouses legally as a spouse. Under spouse, under 2A is a domestic partner. If you are a spouse, if you have a spouse, then you can also have a domestic partner. So spouse kind of overrules a domestic partner. So, but it's not really 2 and 3, so they put it as 2 and 2A. 3, as I just mentioned, any child 18 years or older. Couple of important notes under this one. I'll do it this way. A stepchild is not considered a child for purposes of 4201. I'm going to say that again. A stepchild is not considered a child for purposes of 4201. Also, an adopted child becomes the child of the adopted parents, but they are no longer the child of their biological parents. So legally, their relationship with the biological parents ends when they are legally adopted, and they become the children of the adopted parents. Number 4, either parent. Now, another caveat to this is foster parents. Foster parents are not included on the list. You don't see them listed there. The foster parent must either legally adopt the child or be the appointed guardians, which falls under number 6, in order to have status as someone in control of disposition. 5 is a sibling, 18 years or older. 6, I just mentioned, is the appointed guardian. I will get into the people in order who can entitled to share in the estate that the law considers in a second. 8 is a duly appointed fiduciary of the estate. 9 is a close friend or relative who is reasonably familiar with the decedent's wishes. I will go into that in a little bit more in a second. And a public administrator or anyone willing to act on behalf of decedent is last on the list, and I will also comment on that. I think it's also important, because we get a lot of questions about this, is power of attorney. So you don't see a power of attorney listed on here. So can a power of attorney, if they're not listed here, do they have rights? No, a power of attorney, if the power of attorney is a full power of attorney where it's not, you can, as you probably know, if you give someone power of attorney, you could say, I give you power of attorney to deal with my bank accounts or bank end transactions or my real estate transactions. So if it's not something where it's selected or selective and it's a general durable power of attorney, then that person does have the ability to appoint someone as an agent, but they can't appoint themselves as an agent. So it's important to note that they can't appoint themselves, but they can appoint somebody else. So going into where you see the single asterisk and the double asterisk. So that first one, any person entitled to share in the decedent's estate in the following order. So these are the people that if you had 3 or more grandchildren, you have to have majority. So if you have, 7 grandchildren, you need 4 of the 7 to agree to move forward with whatever you're going to do. It gets a little tricky as you get down here because you might have larger groups of people who are hard to come by and find. But at this point, honestly, if you get down here and you're dealing with cousins and uncles, and you might want to talk to the executor if there is one, or the attorney of the estate, or advise them to do so in order to make sure everything is covered. But you do need a majority of the people in this list of 1 through 9 if you are now dealing with somebody here because you've worked your way down. There's nobody higher who has control of disposition. I mentioned a close friend or relative is number 9, or the public administrator, that's number 10. So the thing about that is they don't say it on the first part, but in the second part they say you do have to complete, if you're one of these people and want to have control, you have to complete the at-need written statement of person having right of control. So we have those forms on our website. If you are the person at need who's not the agent, it's called the other than agent form. And you are basically attesting that person to you as the funeral director that they know of nobody else above them on the list who would have rights to control the disposition and therefore are accepting that responsibility and telling you they are legally allowed to accept that responsibility. And it's also important to note that the at-need written statement is not the same as the agent form. That has sometimes gotten confused one with the other. We will, as I said, go through the agent form itself momentarily. All right, so what else does the law talk about when it comes to the hierarchy? They actually give us some what-if scenarios so you know whether or not you need to work with that individual. So the first part is we call the next in line. So if the person, you get down the list, you find the person who's in control, but that person is either unavailable, unwilling, or not competent to serve, you go down the list to either another person on the list who has the ability, is willing, is competent, is available, or you go down the list to the next person on the list who is available. Equal authority or equal priority, again, children, siblings are the most common that you would come across. And then if you don't have somebody, then you go down the list. So it's important, I want to mention about unavailable. Unavailable, the test is reasonableness. That's kind of what the law always defaults to when there's not something more strict. So if a person is not reasonably available, which means for you that you just, under normal circumstances, can't find the person, the family's not telling you about the person, something along those lines, you can move on. You are not required to hire a private investigator, take additional steps to try to find these people. That is not your job. That has been told over and over to us by the Bureau. Even when we try to throw a question at them that seems to us like it's in the gray, they just seem it to say to us it's much more black and white from their standpoint. You have no responsibility other than just taking reasonable steps. One question that we get a lot, or assumption we get a lot, is that if somebody who has the right to control disposition happens to be incarcerated, that they are immediately deemed unavailable. That is not the case. There are circumstances where someone incarcerated would be reasonably available to work with the funeral director in terms of handling final disposition. So just a caveat not to assume that the person is unavailable simply because they're incarcerated. So what is the duty of the agent? So you are the person in control. What is your legal obligation? Your legal obligation is to carry out the decedent's wishes to the extent that the law says you should, and that is practical to do so. So you can look at things like the financial capability or capacity of the estate and other resources. If somebody wanted a big elaborate funeral that was going to cost $20,000, but they only have a couple $1,000s available, then obviously you're not going to be able to fulfill their wishes because you're not responsible for coming up with the money. So you can do it to the extent practical. You also should follow the decedent's moral and individual beliefs to the largest extent that you can. The person who is in control is not also liable for paying for the funeral just because they're the agent. It's very important to keep that in mind. A lot of times folks assume that because you are the agent that you are now also responsible for paying the bill. So it's important that you remember this as you're working with the person in control so that you can secure payment for the services you perform. With regard to carrying out the decedent's wishes, there was a case. There's not a lot of case law on these issues, which is a good thing. But there is one from 2017 in New York that deals with this that I'm just going to walk you through so that you have an example of how this might work. So the situation is a woman had died and she did not leave any specific written instructions as to how she desired to be buried. She had been divorced twice from her children's father. So she divorced, got married, divorced again. And she had purchased a cemetery plot with him decades ago. Her surviving adult children were the legal next of kin, and by law were the first in line to control her final disposition. So after her former husband's death, she, along with her sister, then purchased a cemetery plot in her family's home country of Israel. So she had the cemetery plot with him, but then got a different one later in Israel. In the years immediately before her death, she continually expressed her desire to be buried in Israel to her sister and to her home health aides. While she did not put these words or these wishes in writing, she did provide her adult children with information relating to her newly purchased plot in Israel. The children, upon her death, wanted to bury her in the plot she had purchased with her ex-husband or their father, who was located in New York City. The woman's sister petitioned the court to override the kids' decision and to have instead their mother interred, instead of the mother interring in New York City, arguing that that was going against what the mother had been telling others, and instead have her go to Israel. After hearings, the court held that the adult children's testimony had focused primarily on what they thought their mother would say or do rather than what she actually said, and as such did not represent the personal and direct knowledge about their mother's wishes. So meanwhile, the home health aide testified that she had actual conversations with the decedent where she had clearly expressed her desire to be buried in Israel. So while they heard some things from both sides, direct over indirect, so the court ruled that she could be buried in Israel because of those circumstances in the conversation during the hearing that they had. So the law basically is reiterating that important point, that you have a list of people who are responsible, that the survivors have a responsibility to fulfill their loved one's wishes, and the decedent's wishes are paramount to the survivor's preferences, and anyone with knowledge or evidence that the legal next of kin is acting against the decedent's wishes could petition to have that action stopped. So it's important to keep that in mind. Again, the takeaway is always that where there is evidence of a family dispute, or if the funeral director has knowledge or reason to believe that the next of kin is not acting in accordance with the decedent's written instructions or wishes, you should pause and to direct the family to get a court order directing them how to proceed. We say this over and over again. If you're not sure, stop and get them to go to a court. There's another option which I'll go over, but don't just wait and take your time, because you don't want to get caught up in a legal dispute. All right. And going down a little bit more through this second section of the law, a funeral director can also serve as a person with the right to control disposition. So if you happen to be on the list, or if you were appointed an agent, you can act in that regard. However, if you are acting that way, you cannot receive any form of compensation or receive a financial benefit. Pretty clear in the law. The other case that they talk about are orders of protection. This is from the 2012 amendment. It's known as the Anti-Domestic Violence Law. So what that says is a person who otherwise would have control because they fall on the right priority list, or even if they were appointed as an agent, is prohibited from serving as the person in control if either they were the subject of an order of protection at the time of the person's death, or they were charged with the decedent's homicide. Now, charged with the homicide is different than being arrested or suspected. That's not enough. You actually have to be charged with the crime in order to be prohibited. This can be waived by a court if they say it's in the interest of justice to do so. There was actually a case back in 2020 where this was looked at. So in this case, the wife had died in December of 2019 and was cremated. Her ashes were given to her daughter because the wife had an order of protection against her husband at the time of her death. The husband then went to the state Supreme Court seeking an order to control disposition of the ashes of the wife. The husband sued his daughter and the funeral home, claiming that they wanted to have control. According to the court's documents, the daughter had stated that she had already scattered all her mother's ashes in Lake George and that she then threw away the container. So the court took all that information in, and their decision was that the husband was declared to be the person who has the right to control disposition of remains of his spouse. And they further declared and directed that the temporary order of protection that was issued is not an order of protection within the meaning of 4201 of the Public Health Law that would have otherwise disqualified the husband from controlling the disposition of remains. And even if they were wrong and it was an order of protection that would disqualify him, the waiver of the disqualification is appropriate in the interest of justice. And therefore, they said if there was ever an event where they found more ashes or the box or the container, that the daughter had to give it back to the funeral home and or so that it could be delivered directly to the husband. For me, the two takeaways in this is clearly you have to look at the fact the judge used the phrase interest of justice as a reason for the decision. However, I find it extremely problematic that the judge interpreted the final disposition law in a way that is clearly contrary to the plain language of the statute by saying that it wasn't the type of order of protection that would disqualify the husband, because an order of protection like this is clearly exactly what the law, in my opinion, would have done. But again, just another example of how important it is to make sure that wherever there's conflict, you take a pause so that you are not caught up in any legal disputes. All right, we're going to go over now to the actual agent form and walk through that. I've highlighted some areas that I'll just talk about with you. So as you all are probably very familiar, so you name the person that you want to control your remains. You then have the ability to give special instructions. Those special instructions go to the thing I mentioned earlier, which is the person in control is supposed to deal with disposition consistent with the decedent's desires and their beliefs. So if you put information here, that gives that person very clear instructions as to what they are supposed to do, not what they want to do. You also are supposed to let folks know if there are pre-need funds available. Just to note, that does not mean that you have to use the firm that's listed there. It's just to help locate funds that are available. As you know, these are all portable when you have pre-need funds. You would also then obviously name the agent so that everyone knows. You are also entitled to name successor agents in the event that the first one is unavailable, unwilling, or not competent to serve. So then you still have the ability of this form to be valid. And at the end, I didn't highlight it, but it's important to note, it states that this appointment becomes effective upon my death. So this is very different from a form like a power of attorney, which is only valid while the person's living. So we also get that question. Somebody comes in, they're like, oh, I have a power of attorney for the deceased, and this person was their power of attorney, so they have control. No, they don't. They're not, as I mentioned earlier, they're not on the list, and a power of attorney legally ends upon the person's death. The same is true for a healthcare proxy. A healthcare proxy is not someone who controls final disposition. They control your healthcare decisions, and that ends upon death as well. The only provision in a healthcare proxy that survives death is the anatomical donations that you put in there. One other important note about power of attorneys: if someone appoints someone else if the person who's appointed as an agent at that time, they're not going to have a power of attorney, but down the line, by the time the person dies, the person appointed as the agent now has their own power of attorney. That power of attorney cannot step into the shoes of the agent and now act as the agent. So, for example, I appoint Kelly as my agent. Several years later, I appoint my friend as my power of attorney. I now die. Now, my power of attorney, I'm sorry, I did that the wrong way. I appoint Kelly as my agent. A couple years later, Kelly's best friend becomes her power of attorney. I die. Kelly's friend does not become my agent. It does not work that way. The power of attorney cannot step into the shoes of the agent and serve as the agent. Going through the form a little bit further, you can revoke this form at any time. And you would do it on the form this way by signing it. You can have obviously a later date, so that's simple and clean. It can be done other ways as well, which we'll go into. The form must be witnessed by two people. A funeral director can be a witness. Again, you can't be an agent unless you're going to not take any money, but you can always be a witness and still perform all the services normally and receive money for the services you perform. At the end is the agreement that the person is acknowledging that they are accepting the appointment. This ensures that the agent can't be appointed without both their knowledge and consent. So you're like, oh, I know that I'm being appointed as this person, and yes, I agree to be the agent. The next couple of sections start dealing with what is a controlling document when it comes to this. So clearly, if you have an agent form properly filled out, that's top on the priority list, clean, no issues. But if you don't have that, can you rely on a will? Yes, it says you can rely on a writing, including a will. But the will has to be very specific. It has to designate in it the person to dispose of one's remains and direct how to dispose of those remains. They should, to be valid, a will, have the same or substantially the same language appointing a person as the agent form. This is different from having an executor or executrix listed in the will and saying, well, the executor came in and they're going to control disposition. They're not on the list. If you go back to the priority list, an executor is not on the list. That's not enough. It's also not the same as a clause in a will that says, I direct so-and-so to pay my just debts, including my funeral costs. Paying for your funeral costs does not put you in control. I just said earlier that the agent is not responsible for financial payments. So that's not what we're talking about. What I'm talking about is you actually, in the will, have to be very specific about what you're asking that person to do, which is dispose of your remains, and be specific as to what your wishes are in order for the will to substitute as the writing that takes number one or position on the hierarchy list. If you have an appointment of agent form that's executed, you can do another one later. You can also, if you have, and that's going to be the most recent one's going to be the one controlling. Also, if you have an appointment of agent form that's executed after you put a will in place, and the will would have been the one instrument that's controlling because you had the language, the agent form is going to take control over a will. So if you have a will and an agent form, the agent form supersedes the will, and the most recent of any written document, date-wise, is the one, as long as it's valid, that's going to control. I mentioned already you can revoke by a written instrument. It actually states that revocation can be done through either executing a subsequent written instrument, meaning a will or agent form, or by any other subsequent act by the decedent evidencing a specific intent to revoke the prior written instrument. So what does that all mean? That all means if you have somebody saying that this is no longer valid and you're not really sure if this other form or where this form is, or if this writing is valid, stop and tell them they need a court order to direct you where to go from there. Because again, when you're not sure, pause and seek help from the legal system. If the decedent's spouse or domestic partner is designated, that designation is automatically revoked if you are divorced or legally separated from the spouse, or if you were domestic partners, there's clear termination of the domestic partnership. Now, divorce is clear. Legal separation is different from just being separated. If you are not legally separated, and that's a document that is going to be signed by both parties, that an attorney is going to be involved in drafting. It's going to deal with financial matters and who takes care of the kids and all of those types of things. Barring one of those legal separation agreements, you are still married unless you're divorced. And even if you've been living with somebody else as a domestic partner for years and years and years, you're still not divorced, and that spouse still is the legal next of kin when it comes to dealing with final disposition. Moving on to the next couple of sections of the law. These next couple of sections deal with liability protections. So the first part says a person acting reasonably in good faith. So a person meaning someone 18 years or old. And this is dealing with the individual who's coming to you saying they have the right to control disposition. So if that person coming in, if they're acting in good faith, is protected from liability for doing any of these three things: representing themselves as the person in control, disposing of the remains if done in accordance with the law, or identifying a deceased person. So the law protects those people from doing these things. In addition, a funeral director has protection, and so does the firm. As long as you're acting in good faith and reasonably, then you can be protected for carrying out either the written instructions or directions of the decedent sent out in the appointment of agent form or will, or the directions from the person saying they have control, but only when you're getting a written statement from that person saying they are either the designated agent in a will or in a form. They have no knowledge that they executed a will or written instrument that would take away their rights, and therefore and have somebody higher up, so they are the person in control. So what does that all mean? How do you deal with all that? We've created, as I said earlier, both an at-need written statement of agent form and an at-need written statement of a person other than agent form. Those two forms will protect you. It'll cover everything you need in the law. So if you haven't already been using those, go to the compliance page of our website and grab those forms and use those going forward to protect yourself as the law intended to. The last section of the law deals with dispute resolution. So disputes regarding who has control to disposition, where the people themselves can't resolve it, shall be resolved by the court. So I'm not just telling you to go to the court because I think it's the right thing to do, even though I do think it's the right thing to do. The law is telling you to go to the courts because it says that those disputes shall be resolved by a court. However, it's important that you are reasonable as well, right? So if a funeral director wants to work with folks, you won't be held liable for refusing to provide services if the dispute exists until you get that court order, or you could get a form signed by all parties to the dispute establishing who has control. I will tell you that if you're going to do something other than, or follow something other than a court order, you need to go and have certain provisions in there. So say there's 3 kids and they can't agree on cremation or burial. You tell them to go get a court order. They come back and they say, okay, we all agree. We now want to bury mom. Okay, that sounds great. But at that point, now you want to say, I need this in writing, and I need you to have a hold harmless clause, mainly basically saying, we want to bury mom, and we agree that this is what we all want to do, and we agree to hold the funeral home harmless for taking these actions based and relying on what we're asking them to do. It doesn't have to be a written legal document. It can be in an email, be on a piece of paper. It should be something that they all sign off on, and that will help protect you. But whenever you're dealing with a dispute, even if you are able to resolve it without a court, then please make sure you put it in writing to protect yourself. Normally what happens, or most of the time what happens, is you tell the folks, you're in a dispute, I have to stop. Law says I need some resolution by the court unless you guys can all agree. They don't want to go to court and wait. They all of a sudden come back and they all agree. Don't take their word for it. You need to have it in writing to protect yourself. All right, so believe it or not, we have now gone all the way through the law. So I'm just going to see if you guys were paying attention. So we're going to go through a couple of questions. I'll pose the question to you, give you a second to think about it, and then I will show you the answer. Can a funeral director be appointed the agent? Yes, but as I said, if you're the agent, you can't be compensated or receive a financial benefit. True or false? The person paying the funeral bill automatically has the right to control disposition. False. And as I mentioned, the person with rights to control is not responsible for paying the bill. So I have the right to control. I don't have to pay the bill. The person paying the bill, just because they're paying the bill, doesn't automatically mean they have the right to control. Is it possible for a person to be appointed an agent without knowing it? They are not able to do that because, as we went through the form, they have to acknowledge it and accept it in writing by signing the form. So there's no way that they could come back and say, I had no idea. They might have forgotten, but there's no way to say I never was asked and I never agreed to this. Does a person need an attorney or a notary public when filling out an agent designation form? You do not need an attorney, but you will require 2 witnesses. Again, one of them can be the funeral director. Is a funeral director responsible for or required to obtain documentation for proof of a domestic partnership? You are not. So again, I do it nice and simple like this, right? You do not. The law says you don't have to. But what I'm going to tell you is it's always good to have some reasonableness behind your reliance on these people. One of the easiest ways to get that is if you're using the are at need form. In there, that person is attesting that they have right to control and they know no one else who would be above them. The only person who could be above them would be a spouse. So you can rely on the law as long as it's reasonable to do so, which makes sense. But again, it's not unreasonable to ask someone to show you some invoice, bills, a mortgage, anything like that, just to show that there was intention to form a domestic partnership if they don't have the registry or the certificate. Are there any I gave you the answer already. Are there any situations when the designated agent or legal next of kin may not have a legal right to control disposition? There are those 2 situations where they're either under an order of protection or they were charged with the homicide. Again, charged, not arrested or a suspect. Okay, here's a scenario. 3 children meet with you to arrange for their father's funeral. 2 children want dad to be cremated. The 3rd does not. What do you do? Follow majority rule, refuse to cremate because there's an objection, tell them you can't help them and direct them to another funeral home, wait and direct them to obtain a court order to determine who has control. So after 2022, with the change in law, you now go by majority rule. Prior to 22, you would have gone to the last one and had them go and get a court order. But today you are allowed, as long as you have 2 of the 3 or a majority, to go ahead. Can a funeral director act as one of the 2 witnesses for the agent designation form? Yes, you may act as a witness. Of the following individuals, which one has the highest ranking on the disposition list? The executor, the public administrator, a grandchild, or a close friend or relative who knows the decedent's wishes? Probably the hardest one we'll ask. The answer is grandchildren. On that subsequent list I showed you of the sharing in the estate, grandchildren is 7, the fiduciary is 8, the close friend or relative is 9, and the public administrator is the bottom of the list as 10. True or false, a designated agent can refuse to serve at the time of need? True. You can be unwilling, unavailable, or not competent to serve. You either go to another person in that same level priority if one exists, or you go down the list until you get to the next person available on the priority list. Are stepchildren considered children when it comes to the final disposition law? No, a stepchild is not a child. You either have to be legally adopted in order to be considered a biological child or a legally adopted child. If a couple is separated but not divorced, is the surviving spouse still the next of kin? Yes. They remain spouses until they are legally divorced or legally separated. And the last question, does 4201's priority or hierarchy list only apply when a person dies in New York State? Yes. If you die outside of New York State, you do not use the priority list to determine who has control of disposition. As I mentioned at the onset, when you would rely on is an agent form or a valid will under New York law for someone who dies outside of New York State. In those instances, you would still be doing the services and disposition within New York State. As a state law, it only controls what happens within the state of New York. And that concludes the presentation. Hopefully, you found it useful and found a little tidbit or two in there. And Kelly, we can now open it up to any questions that folks might have.
Okay, we're going to start with an easy one. If the mother of a deceased infant is 17 years old, who is in control of the disposition?
We actually had this question once before. When you go back to the beginning, and I said a person has to be 18, as illogical as it sounds because it's the mother does not have any legal rights because she's not 18 years old. So you would go down the list to somebody else. If the father happens to be over 18, he would be in control, and then you would have to go to grandparents, so maybe the parents of the mother, but the mother would not have the ability to control disposition because she is not 18 years old.
Okay. Does the law say that the decedent's wishes, as stated in their will, supersedes the wishes and directions of the next of kin or executor?
The 4201 states that the express wishes in the agent form or of the decedent should be followed by the next of kin or the person in control. So the law does say that you're supposed to act as the person in control, consistent with the wishes and reasonable moral beliefs of the decedent to the extent practical. So again, unless there's something like financial considerations and constraints that would not allow you to, or that person to follow those wishes, the law does say that they have to follow the wishes. So it's the stated preference of the decedent over the preferences or desires of the person in control.
Can the funeral director witness an agent form over a virtual platform such as Zoom?
Yes. There's nothing in the law that talks about how any of the witnessing or signatures can be done. You can use electronic signatures on funeral contracts now. The only form that's specific as to how you're supposed to witness the form and or fill it out is the cremation authorization form. The Division of Cemetery states that if you are witnessing someone sign a cremation authorization form, you are supposed to be on a platform like Zoom or FaceTime where you are watching and seeing and hearing the person, as you're communicating with them as they sign the form. That's the only one that specifically says you have to do it that way. So obviously, if you're witnessing it, you have to see it. So yes, you can do it virtually.
If an agent form is returned to you and you have reasonable suspicion that the form has been forged, how should you proceed?
I would say that there's questions as to the validity of the form, and you need to get court direction to me that shows that the form is valid, then legally valid, so I can move forward. Now, the other thing is, if you don't want to do it that way, you could use the at need statement by the agent saying, this form is in place, it's legally valid, I know it has not been revoked. That's what the form says. So the way the agent form reads that we have is very simple. I can read the beginning to you. It says, the name of the agent's going to go there. I represent and assert that I am entitled to control the dispositions of remains of the decedent, who named me as his or her designated agent or in a will or the written instrument pursuant to 4201. I also attest I am not a person who at the time of the decedent's death is, and then they talk about the other things with regard to the protection. So that person's going to sign there. So from your standpoint, again, it's reasonable. If you have reasonable suspicion, I always say take the safest route and pause and get a court order. But if they filled out that form, you can rely on that form under the law, and you would be fine. So you have two options there. The law really forces the person who's coming forward to be the one responsible for telling you the truth. Again, if you're saying the way the question was phrased is a reasonable suspicion that it's forged, once it's not, then at that case, if I were your attorney, I'd say stop, because you have a reasonable suspicion, so you can't reasonably rely on the form. So you could potentially get in trouble. So I would take the cautious route and have the court intercede.
And we have a side note to the story about the order of protection case that you presented. The husband and spouse had a court date about the order of protection a few days before the wife passed. The court date was postponed because the wife was ill and couldn't attend. And since she died before the husband could get his day in court, the judge then ruled the way he did.
Okay, gotcha. So there's a little bit of a gray area that he relied on there. Gotcha.
Right. Okay. Can an agent sign and accept the appointment of agent after the death has occurred, as long as the decedent had appointed and signed prior to their death?
No, the agent form has to be fully completed and in place before the person passes. So if it's dated after their death, or it was unsigned and they signed it afterwards, legally that's not a valid agent form.
Okay. Is the at-need written statement required to have on file?
The form itself is not part of the law. That's something that we created and the Bureau has endorsed as a good a tool to use. So it's not legally required to be on file, but you do have to have that attestation. So I would say, if I were, again, being conservative, I would suggest that you make sure that you do have that form in the file personally. That's how I would do it. But legally, no.
Okay, a child over 21 makes prearrangements for cremation for their parent. The child then passes away. Many years later, the parent dies. There is no other family members or will or agent or friend to sign. Do we cremate the parent as the prearrangement said, or bury them?
So in that case, since there's nobody in control, I would say you go all the way down to the bottom of the list and you present this to the public administrator, and then let the public administrator decide. I know a lot of public administrators have been very reluctant to authorize cremation because of its irreversibility. We are actually working on changing the final disposition law to clarify that the public administrator is protected from authorizing that form of disposition. But I would not act on that. Personally, I would go to the public administrator and ask for them to provide direction as the person in control under the law, as the last listed person on the priority list.
Okay, if a power of attorney appoints someone as an agent, can the power of attorney be a witness?
I know nothing in the law that prevents them from serving as a witness, so I would say yes, they can. Two separate responsibilities or authorities. So you're just saying that this person is, witnessing the person signing the form. So if you're appointing the agent and then you're watching that agent sign, yes, you'd be fine being the witness as the power of attorney.
If an agent has been identified via the agent form, does it supersede the at-need statement having the right to control disposition form?
Yeah, so the at-need form is not the legal form under the law. The agent in control disposition form, a fully executed valid agent form is always going to be number one in control.
How do we protect ourselves regarding the next of kin for deaths occurring outside of New York?
Not 100%. So if a death occurs, there's a whole lot of scenarios that could come with that. So if a death occurs outside of New York and you're not able to control, you're not looking at next of kin laws in New York in the priority list, then you're really subject to whatever the laws of that state are. So it's hard to know how to answer that question without specifically, knowing the circumstances. It's going to probably vary based on disputes and contention and those types of things. But when we asked this question of the Bureau to find out confirmation as to whether it applied or not, they basically just said that the other state, the state where the decedent passed, is the controlling law. So they would have to comply with that. So as long as they're attesting that they're in control under their state laws, you should have protection. If you wanted to have information on what those laws are, you could ask them to present something from an attorney or a court to make sure that you're covered. But unfortunately, there's really not a lot under the state law that will clarify how you protect yourself from any disputes on the next of kin side. And the reason is you're not relying on the next of, I'm sorry, go ahead, Kel. I was going to say that you
No,
can't,
you're fine.
The reason is you're not relying on the next of kin hierarchy law. So if there is no agent form from or a will from that person that's valid under the state where they die, again, if you have an agent form that was filled out in New York or a will that's valid under New York and the person died, say, in Connecticut, then you could follow those forms. If there's no form, then the person dies in Connecticut, you have to follow whatever Connecticut's law says as to who has the right to control disposition under state law there, and then work with that person for whatever services they want to do in New York State.
Okay. How does the family of the decedent initiate a court order? And what, as the funeral director, is his or her obligation to assist in securing the court order?
So generally, you would go to New York Surrogates Court, which are local courts. There is no obligation on your part to assist, but I would just direct them to go to the local Surrogates Court and to work. They generally, from my understanding, I don't work with them, but my understanding is that because of the circumstances, they are familiar with this having come up in the past, and they understand the timeliness of it, and usually will work pretty quickly to get that done. It's kind of the same place you would go to have a will probated. It's a surrogate court, so probate court. So just direct them to go to surrogates court. But you do not have any obligation other than telling them where to go than that.
Is it possible to have the agent form changed where there is a place for the first and second successor to sign so they are aware of their responsibility?
I'm not aware of, there's nothing in the law that would stop you from doing that. Generally what happens is the person comes in if they're the second successor and the first person's not available, and then they sign the at-need form as an agent saying they know of nobody else, and that's how you do it. Because the bottom line is that person at that time, ahead of time, if they sign, they still have the ability to not, say I'm unwilling or I'm not available. So generally the way we've suggested doing it is as long as the primary agent has accepted it, then the successor agents, it's really on the person asking them to let them know. But you would, as the funeral director, if you can't go to the primary agent because they're unwilling, unavailable, or not competent, you go to the successor agent, and that person would sign the at-need agent form to say that they are accepting it at that point in time. But if you had them sign that form, it's not going to hurt you. It's not going to make it illegal. So if you wanted to add a signature line, it's certainly not anything that would invalidate the form.
And this next question was actually asked twice in a row. Can I, as a funeral director, but not an owner of the funeral home, be an agent and the funeral home still collect money for fees since I don't directly benefit from that service?
No, we actually had that question come up a while ago. We asked, it's the funeral director / firm cannot benefit. So if the firm you're working for is not entitled to benefit either.
Going back to the 17-year-old mom, does it make a difference if she was an emancipated minor?
It does not, because the law doesn't recognize you as a person until you're 18. Your status doesn't matter.
All right, here's one that I've never heard. True or false? The appointer of the agent, and the subsequent agents cannot all live at the same address.
The appointer of the agent, and the subsequent agent, that's false. That where they live, it doesn't matter. I mean, you could, even though you have a spouse, you could be living there. You could name that person as your agent, and that person, even if you got divorced and it was an ugly divorce and you hated that person going forward, unless you revoke the agent form, that person would still be the agent. So the address has no bearing on who you're appointing or the validity of the appointment.
Okay, so the next one is a little bit long, so bear with me, please. If someone is incarcerated and they are the next of kin, the child of the deceased tells you this and states they are in charge because they were arrested for assault on the deceased. Is the funeral director's responsibility to notify the next of kin that their spouse has passed and they are not in control? That's the first part of the question.
So that part is, if you're arrested for assault, unless there's an order of protection or you are charged in the homicide, you are still in control. So that person who's incarcerated, they should be notified, and if they are reasonably available because the prison allows them to be reasonably available, they would still be in control.
Even if they were arrested for assault on the deceased?
Yeah, it's what it says is the only times you're not, if you were the next of kin and you're the only two instances where you lose that right are you're either under an order of protection or you're charged with the homicide of the person, not an assault of the person, a homicide of the person.
Okay, so I'll take the next part of the question then based on that. If the child tells the funeral director that this person is incarcerated because they're wanted for the murder, they've been charged of the murder of the deceased, is it the funeral director's responsibility to investigate this claim?
So I'm going to say legally no, because that person at need form signing, it's going to say, I know of nobody else and I'm the person who has control. However, you could be called into question for reasonableness, right? So you're reasonably relying on this person saying that. If this person was charged and arrested and convicted for that, there should be some kind of court document that's readily available that person can provide to you. And if that was doctored then you don't have to worry about it. But me personally, I would say I would ask for any legal papers, court order, a verdict, a court decision that says that was the case. Personally, that's what I would do. Legally, again, if you use the form and that person's attesting to the fact that this happened and therefore they're in control, you are legally allowed to rely on that as long as it was reasonable. So I hate to put it back on you, but you'd have to decide whether you felt that this person was being truthful and is it reasonable to rely on what they're saying. Ultimately, that's why I would always go with the most conservative approach, and I would always seek something in writing that helps me say, this looks reasonable to me. It looks like a real court decision, and it was signed, and it says that the person was convicted for killing the decedent. So therefore, yep, I'm going to the next person, and they're signing that form, put those two together, if anybody ever came back after you, you are protected under the law.
Are all forms allowed to be signed electronically? If cremation paperwork is witnessed, can they electronically sign and not sign with a pen?
Correct. It sounds ridiculous, which I agree with, but you could send it to them via DocuSign. You're supposed to be watching them sign it via DocuSign and sending it back to you. But yes, they can sign it electronically.
And this is a follow-up to a previous question regarding the son who passed away. If no biological kin is known to exist and a will is completed with the beneficiaries whom are close friends of the deceased, is it okay to proceed with traditional burial?
So it doesn't matter about the will in that case. If you have a close friend of the deceased who knew what the wishes were, and if the wishes were maybe stated in the will or somewhere else, then yes, you could rely on the friends if there's nobody above them on the list. I mean, you've gotten pretty far down the list at that point. There's only the public administrator below you and all the other ones above you. So if there is really nobody else that you reasonably know are available or exist, then yes, you can rely on the close friend who has a reason, who says that they know what the last wishes were of the decedent.
Okay. Do you see any reason why you wouldn't ask for an agent form to be notarized?
I wouldn't, just because it doesn't require you to in the law. And normally what a notary is really just a witness who has a stamp. There's no real extra legal protection for you from that. And since you have two witnesses, I don't think there's a need to go out and look for a notary. I don't see any extra legal protection for you by having it notarized because you have two witnesses already.
When using DocuSign, do you still need to physically witness the signature on cremation authorization form?
Yes, I mean, that's what they say, right? So if it's DocuSign, someone's far away, you're supposed to be on some audio-visual conference where you can see them clicking the button to sign the form. As I mentioned, it's kind of silly. You don't have to do that with other forms, so we'd love to change that, and we probably will work to change that. But right now, the law specifically says you're supposed to watch them click the button to sign DocuSign or any other electronic means.
Okay, that ends our questions today.
Great. That's just might be the very first time I didn't. Oh, dang it.
You're so close. Okay. Can a POA change the designated agent form?
Can a POA change? So if someone, I guess what you're asking is, can they change it to a different agent? If that's the
if they
case,
already have it. Yeah.
So I'm going to go with the agent form can be revoked. I know, again, specifically we were asked, can an agent, can a power of attorney appoint themselves as agent? No. Can a power of attorney appoint someone else as agent? Yes. I am not aware, we never asked, so I was just about to say before this question, the first time I don't have to do a follow-up, but I think I might have to now, because what you're asking is, does the power of attorney have the authority to sign the revocation of an agent form and then appoint a new agent? I've never been asked that specifically. So the bottom line to me is, you can appoint an agent. Can you now change that person's decision and put somebody else in place? That's a very good question. I'm not comfortable saying yes they can or no they can't without getting confirmation. So we will follow up with the Bureau on that one. And I forget, Kelly, I think sometimes when we send the certificate out, or I don't know if there's a way to let folks on the call know, we can send a note out somehow, some way to everybody and let them know what the answer is, but I'm not 100% sure on that one.
Sure, yeah, we can on the follow-up. Yep.
Okay, so we'll pose that question and get confirmation. My guess is if it's a general durable, they're probably going to say if you can appoint an agent, then the POA, while that person's still alive, would have the authority to act on behalf of the person appointing the agent, and therefore I would assume would have the ability to revoke the form and appoint a different agent. But again, that's my gut and reaction, so I'd rather get confirmation because it's not said anywhere in the law, and that question has never been posed to me before. So we will follow up on that one.
On the cremation authorization form, can residents sign where it says funeral director, or does it have to be a licensed funeral director?
It's my understanding that all contracts have to be signed by the funeral director, and the resident does not have the ability to sign any documents. That's under the regulation. So any contracts and authorizations need the signature of a licensed funeral director.
Okay, that might be it.
I'm not going to say anything yet, just in case.
Well, I just want to thank everyone for joining us today. And again, please allow 7 to 10 business days before your portal will reflect the credit from today. And you will also get a letter in the mail with your credit. And always, if you have questions about this or any other compliance issues, please feel free to give us a call or email, and we are happy to answer it. All right. Thank you so much, Mike, and I hope everyone has a fantastic rest of your day.
Thank you all.